Next case set for oral argument here in Lorain County is Cusack versus Cusack. It's case number 21CA011774. Each of you will have 15 minutes to present your argument. The appellant, you will have the option to reserve up to 5 minutes for rebuttal. I'm Judge Guido, so I'll keep track of the time and let you know as you get close to that time. Of course, my colleagues, Judge Sutton and Judge Hensel, will also be on this panel, and they have some questions for you as well. If there are children involved, or minors, we ask that you not use names, refer to them by initials, or something such as the child, some other way. We also ask that you keep your voice up and remain at the podium, since the arguments are recorded and posted on the YouTube channel of the court. We have read the briefs in this matter, and we are prepared to proceed. If you are, would you like to reserve some time?
Yes, please.
How much? You can get up to 5 minutes?
Up to 5 minutes. I'll do that for 5 minutes.
All right, I'll let you know as you get close to that 5-minute mark, and you can decide to either continue or stop at that point and save your time.
Thank you, sir.
All right, if you'd approach the podium, please.
Thank you. May it please the court, my name is Sam Bradley. I represent the appellant, Kevin Cusack, who decided to appear today and observe the proceedings. The first issue deals with stock options that Kevin received during the marriage. As Kevin testified during the trial, and I believe the evidence supported, there was a 4-year vesting period. December of each of the years, he would receive 25% that was eligible to, that vested and then eligible to be sold if the strike price was correct. The problem with the trial court's order is that she did not do any analysis as to the value of those stock options. She effectively treated them as if it was some sort of bonus. It was clear in the record that those stock options were designed to retain and keep higher level employees, such as Mr. Cusack, as employees of the company.
The judge did, if I remember correctly, as a 50-50 split when they are available, when they become available.
Correct, but the problem comes in is how does that 50-50 split work? The judge made a statement that the amount to be split would be after all mandatory or necessary deductions such as retirement are subtracted. There was no definition of what is a mandatory deduction, no definition of what is a necessary deduction, and no definition as to what type of retirement. In theory, and I would encourage Kevin to consider this, is to take any of the proceeds and deposit them into a 401k plan or an IRA plan if he's eligible, and then the net amount would potentially be zero. I don't think that's what the judge intended. I know that there's a post-decree motion to show cause as to that definition that wasn't ripe for appeal, but it deals with the mandatory necessary retirement language.
Counsel,
Yes.
Before we get too far into the future stock bonus vested or unvested, at the time of trial, it's my understanding that Mr. Cusack had 538 stock units already that the trial court noted in the entry. It was noted in his summary of assets they had approximate value of $78,000. And then I don't see anything in the judgment entry that disperses any of those assets. I'm not talking about the ones that are coming in the future.
Well, and that was one of the things I brought up in my brief, is that there was no indication, did those apply to the stock options? Was she referring to the number of shares available to Mr. Cusack within the stock options? Or was she referring to a separate number of shares of stock? And it wasn't clear in the record nor in the judge's order.
Yeah, I mean, it reads kind of, this is going to happen in the future when she's doing the distribution part of the order. To me, I could be off base.
I agree, I read it that way as well, but I also read it as, gee, are these part and parcel? And that's the nice thing where I have the benefit is I wasn't trial counsel, so I'm able to come in and look at this with a fresh eye, similar to the Court of Appeals.
Well, doesn't that create a little problem though, if she hasn't disposed of that $78,000 worth of stock?
Well, it would.
It's gotta be a final appealable order, she's gotta.
I agree, but the question comes in, I think, before the judge, before you rule it whether it's a final appealable order, is the judge should tell us whether or not that's part and parcel of the stock options. So if it's part and parcel of the stock options, then she has disposed of it. Now, if it's a separate stock entity or a group of stocks, well then, yes, you're right, Your Honor, she didn't complete the tasks that she was responsible for doing. Then the other issues, and if you read, I'm sorry, the Banning case, it does a very nice job of telling us the different ways for a trial court to divide stock options. Find out if they're transferable or not. Find out if they're not transferable, do we get a value of what the strike price is versus the market price and have option holder to pay former spouse now? Or do we do a wait and see with a reservation of jurisdiction to divvy up the net profit at a future date? I thought all three of those methods, transferability, value now, or wait and see, were great methods that our trial court perhaps could have used in this particular case. She kind of did a modified wait and see. When you're able to do it, sell them and then somehow deduct these appropriate and necessary and retirement monies from the net, or to create a net and then divide that net. Again, maybe I like to be a little bit more precise, but without precision, it's hard to advise a client what an appropriate deduction would be, what is a necessary deduction. I mean, frankly, I'm sure Mr. Cusack would believe that everything that he has to buy each year is a necessary deduction. You know, my food, my grocery, clothing, etc.
And if the trial court reserves jurisdiction on spousal support, is this the type of jurisdiction that it's reserving to figure out the best way in the future to resolve these issues?
I don't think so, because one is under 3105.171, the other one's under 3105.18, which leads into the next argument. The judge also ordered not only the existing stock options divided, she also ordered any future stock options to be divided. Any future stock options that are acquired after the date of the divorce, I believe it was October 18th of 18, thereabouts, Mr. Cusack, or Ms. Cusack and Mr. Cusack, those are deemed tantamount to marital property. And that clearly flies in the face of 3105.171. Once a divorce occurs, any property acquired after that date belongs to the party who earns it or attains it.
Counsel, did your client have future stock options at the time of the divorce?
He had hopes of future stock options. He had not received any at the time of the divorce, but Mr. Cusack had a number of different jobs. Just in the time of the divorce, he had 2 jobs. One was with Schwab, and the other one, and I apologize, apologize. Needless to say, he had 2 separate jobs, and I apologize.
Okay, thank you.
In fact, the first job that he left increased his income substantially because they paid him a severance package. He was able to cash out different things that became available to him as a result of his leaving that job. So his income skyrocketed that year to $500,000. The court, as I point out in my, I believe, third argument, is that that was an anomaly. You can't, I don't think you should be able to calculate support on a 1-year anomaly. In fact, the statute even makes reference to income not likely to repeat itself, at least the child support statutes do. So here we have monies that were, I guess, like a bonus of sorts, but unlikely to recur unless, again, the next company decides to let him go and give him big severance packages, et cetera. His base salary, as the court found, was $275,000 per year. The court also made a finding as to his net income, which goes to argument 3. Out of his net income, Debra would receive $108,000 per year in spousal support. She's then entitled to 1/2 of the unearned bonuses that Mr. Cusack is supposed to receive. Yet he hadn't received any of those. And we know with the Berner case, a formula, Berner and Kunkel, a formula division of bonuses is frowned upon. Here, when he gets a bonus, 50% to wife. That's nice, I understand it, but again, that is better used for a motion to modify the support, not just a blanket forever 50-50 division of those things. And again, taking out all mandatory and necessary deductions, such as retirement. That again, creates years and years. Assuming he gets an annual bonus, we may be in court every year trying to figure out what was a mandatory, necessary retirement subtraction from that bonus.
Counsel, I don't mean to interrupt you, but you're at 4 minutes and 22 seconds
Left.
so
Okay.
I didn't want to interrupt you, but
I appreciate that.
Yeah. Would you like to reserve that time or continue?
I'd like to reserve that.
All right.
I appreciate that.
Then you will have that 4 minutes, 22 seconds for rebuttal. We'll hear from opposing counsel. Of course, you'll have 15 minutes.
Thank you very much. Good morning, judges. Happy to be back in this court. The standard of review, obviously, is abuse of discretion. Abuse of discretion means you nearly need to have a judge say, I hate you and I'm going to punish you. Or either that or there's got to be a major error of law. There is absolutely no way that any of the appeal errors that we have rise to abuse of discretion. It was an attempt by the judge to resolve the matter, to try and provide a way in the future where incomes go up and down. We've got a long-term marriage. The judge reviewed each one of the criteria for setting spousal support. And particularly of reference in this case, I have a non-functioning person. She has multiple sclerosis. It is a debilitating disease. It gets worse and worse. It will eventually kill her. And these two enjoyed a lifestyle that was great. What we have to divide left in this case, there are no other major investments. It was whatever he had in the way of earnings that he had received, whatever he had received in equity grants, whatever he had received in the stock options, which could be exercised at a future point in time. They had spent literally millions and millions of dollars and not saved it on vacations, on restaurants, Christmas. And so we then have lifestyle, which comes into play. And again, I always find it tremendous to review the cases that are cited by the other sides. If I could just run through some of the notes on assignment of error 1, there's an equal division of stock indicates that there are no mechanics to do it. That's not correct. There are mechanics there to divide the stock as it comes through in the future. Assignment of error 2. There is an equal division of options, the equity grants, and the appellates. All of those things, by the way, are benefits that, in essence, are income. They are benefits that an employer provides to encourage an employee, stay with me. We like you. Here's what we're going to give you. So again, these aren't just buying at some later point in time a piece of real estate and then it increases in value. This, in essence, is income. It is, in essence, something that the court sought to divide to try and get these people to maintain basically the same kind of standard of living. And as employment goes up and down. Assignment of error 3. There's no way that the spousal support award in this case, in any way, is out of the ordinary. There's $108,000 in that particular year. There basically was $500,000 worth of income. So to complain about that, I find that to be, as I said in the conclusion, sometimes you better look out for what you ask for because you might get something else. Bottom line is we do have pending motions on consent. We have motions pending on increasing spousal support, which frankly we need to get back out of this court of appeals and get the trial court to get those addressed. All of the factors in 310518 were considered: income, assets, need, and again, the absolutely horrible disability that my client has. Absolutely awful. I would not wish that on anybody in this world. Taking a look at the cases that they cited, but again, I think one of the cases that is going to control here is going to be the Orton case, the one that came out of Summit County. And in that one, the judge really went to, this is what we're going to do, and opposed to what they say percentages shouldn't be used. No, there was a percentage formula used in the Orton case. And it is entirely appropriate here. As his income changes up and down, he will receive the benefit when it goes down. So, I mean, the court retained jurisdiction, seeing that there could be problems with the way that this case would develop, potentially in the need of my client, as she continues to diminish. I mean, the record is replete with the fact that she has to have somebody basically help her do everything. And there have been multiple injuries that happened to her during the case. Just falls down. And the Green case, the appellate court reversed when the options were held to be sort of valueless. So no, there are some value that is imposed here. It's a value that he is earning because it is basically his income. It is something that he receives as a benefit by continuing to work. It isn't something that should be disregarded. Obviously, they've got that. In the Frederick case, the division of options by Cusack, again, helps to eliminate further litigation. You look at the HUD case. Always, the trial court should be allowed to tailor the remedy to the litigant's circumstances. In the Rice case, Cusack's percentage, everything needs to certainly be divided equally. And in fact, even in the Orton case, which again was affirmed by this court, the wife wound up with having more in the way of net disposable income than the husband did. Mr. Cusack's theory is, unless it is no more than equal, it's not fair. And that's not the law. And that is not what you find in Oregon versus Oregon. Again, need, standard of living, all of those things exist. All of those things have to be considered. But again, their theory is, oh my God, it's not equal. She's getting more. In this case, she's not getting more at all. Again, those are things that we could maybe take another look at when we get back in, because he's changed jobs. There's all kinds of things that have to be readjusted here. So their theory on that, I think, is just absolutely abysmal. And again, in the Gore case, again, trial court to consider expectancies. As to assignment of error 2, again, standard of living is a major criteria. 50% of the bonuses, and in the Oregon case, it was 33% of the income that was earned off of a separate property investment. So again, even though you may have separate property in Oregon, which is affirmed by this court, which their decisis indicates we should, keep in play, The bottom line is, out of his separate property investment that he made, he was still looking at getting hit on some of the income in order to keep that lifestyle correct to meet the needs and necessities. Assignment of error 3. Oregon allows sharing the accountant's success in business. There is no abuse of discretion. That standard isn't even close here. Everything was considered. There was no error of law, none whatsoever. Again, he is the beneficiary of getting this thing done before 2018 passed on December the 31st. That's when the law changed. No longer can you deduct spousal support from your income or gross income or for taxable purposes. He is receiving a huge benefit by doing that. You know, I mean, basically by doing that, you're able to really equalize the incomes. But again, equalization in my case with my client and her needs. You know, he doesn't have to have anybody help him go from here to there in a room. He doesn't have to have anybody help him get in to get groceries. He doesn't have to have anybody help him to get, you know, her to the beauty department. You know, he doesn't have any of those needs. Her needs are greater than his. We'd ask that the court would affirm the decision and allow the matter to get back to the trial court because, again, circumstances have changed since we were in court. I defer. I hope I can answer any questions you might have.
I have one remaining question, and it's the same one that I asked counsel for the appellant. There's some stock that he held prior to the trial. How do you think did the trial court disperse that stock?
My understanding, it was still options. You know, it has been options that have, yes, the options were exercised, but it was never divided. No, my understanding is the same as I believe certainly the other counsel says. No, those were divided.
Even though the trial court,
Those are 50-50, you know, they were stock options.
even though the trial court's entry says at such time as husband receives bonuses, they'll be dispersed, and one half will go to the wife? That's the language.
Bonuses are bonuses. The options are a little bit different than a bonus, though. Bonuses, you actually receive checks, Judge. The options are a little bit more nebulous as to what they are, but they're still, as is even in their own case that they cited, they still are there, not valueless items. No, it's my understanding that those are 50-50.
Okay.
You know, because I think that the judge was looking at them as, okay, here's these options, okay. And I guess in her mind, she did not transpose them to being actual property at the time, but I mean, certainly it was property subject to division. And it was my understanding, the way it read, that those were to be divided also.
And that language is contained within the spousal support portion, not the asset distribution portion.
Yes, I think it was just an additional spousal support award. I mean, spousal support can be in the way of form of income, it can form of deduction from your pay, or it can be in the form of property. My revised code is clear. Spousal support can, in fact, be division of property. And if, in fact, it is, that's exactly how I looked at it. And the fact that it's division of property, if it is classified as division of property, then, yeah, there is a motion for relief from judgment there. If, in fact, it's not going to be 50-50 over to her, because that would be something that had been missed. But the clear intent that I got was that, yeah, it was to be divided equally.
Thank you.
But you do have me worried. You got me a little bit worried here. Is there anything else?
No, excellent.
Thank you.
Thanks.
Thank you very much, Attorney Jones. Attorney Bradley, you'll have that 4 minutes and 22 seconds left.
Thank you, Your Honor. Mr. Jones made reference to the Oregon case, and the Oregon case is inapplicable to this particular situation. Oregon was a post-decree situation where there was a modification being requested. The man was retiring from work and wanted his spousal support to be reduced because of his attaining the age of 62. The wife wanted to utilize part of his pension for his income for that, and the trial court said, no, we can't use the pension because you waived off any future claims, you got your portion, he's getting his portion. However, during the trial, we divvied up stock in a company that he owned. And therefore, we're going to award to you a percentage, or would consider that income from the stocks, the dividends, as part of his income. That's not happening in this particular case. The stock options that were divided have not yet even been earned or received by Mr. Cusack. Now, part of them were in argument one. Those stock options, the ones with the 4-year vesting schedule, those were addressed and divided. Then the court said future stock options would be divided. The case organ doesn't apply. And again, I can see where Mr. Jones is saying, well, hey, it's property and therefore 0.18 allows for a trial court to award property. Well, the statute specifically says property that's been divided by the court in the divorce decree. So the trial court has to divide the property and then say, well, for a better spousal support award, we're going to transfer some of this asset over to this spouse to try and make a better spousal support award. It's not what has happened here. We have post-decree property that Mr. Cusack may or may not receive being ordered divided without any analysis being done as to how many shares may he receive, what are the values of those option contracts, when can they be exercised, when can they be divided. It's just a menagerie of future problems in this particular case as to how do we guess with an unknown. It's almost like if Mr. Cusack decides to take some of his retirement money and buy an apartment complex, does the court then have a right to say, well, Ms. Cusack gets half of that apartment complex? Because he acquired it after the divorce and it's a piece of property. It's not necessarily similar to a stock option, but it does have some risks like stock options because you have to get tenants and work it to make sure that it is maintained. So, okay, she gets half of that. Or she gets half of his clothing that he buys after the divorce. There has to be a cutting point. That's 0.171 makes it clear that during the marriage means that time period starting on the day of marriage through the day of divorce trial, unless the court finds that to be unreasonable. Now, in this particular case, there was no analysis as to that second component of end of marriage, whether it's unreasonable or not. I agree with Mr. Jones that an analysis of a spousal support award is an abuse of discretion. In this particular case, dividing future unknown bonuses by a formula of 50% is unreasonable, unconscionable. There's no thought whatsoever being given to it. Just we'll assign this formula, and contrary to Berner, that's what Ms. Cusack shall receive.
Counsel, with that, you have used your time. So I want to thank you for your arguments, both of you. And we'll take it under advisement and issue a decision in due course. Each of you will receive a copy of the court's decision on the date's release. You can also keep an eye out on the Ohio Supreme Court's website where our decisions are posted. Thank you for excellent arguments this morning.